The next panel is dealing with the new Ontario Court of Justice rules of criminal procedure. And on that panel, we have our Criminal Lawyers Association President, Norman Boxall. Hey, Norm. We also have Associate Chief Justice Griffith, who's coming up to the stage, and as well the Honourable Rick Libman of the Ontario Court of Justice.
Thanks for attending. This panel is to make sure Mark Sandler doesn't get more business than he already has. And so we have already introduced our guests, Justice Griffiths and Justice Libman. So Associate Chief Justice, go ahead.
Thank you. Good morning, and thank you for coming. I appreciate that on a Saturday morning, at the end of the morning, criminal rules are probably the last thing that you want to sit and listen to. The only consolation I can give you is that it's a really rotten day out, and it's much nicer inside here. We at the Ontario Court of Justice have spent really 2.5 years developing new criminal rules for our court. They are different from any other rules that have gone before in Ontario, and frankly, they're different from any other rules in the country. We started with the thought that case management and the involvement of the judiciary in case management is much more important now than it was in 1998 when the last rules were drafted. We're also aware that there are increasing numbers of self-represented folk coming into our courts. So we wanted to make the rules simple and accessible. So they're in plain language and hopefully will be accessible to everybody. I know you received a copy today as part of your materials, but if you go on to our website, ontariocourts.on.ca, and go to the Ontario Court of Justice website, you will find copies of the new rules and of the forms in an electronic format. There are, at the end of the day, 5 rules, that's all, and 3 forms. They apply to criminal proceedings, but not to provincial offenses or municipal proceedings. They come into effect on July 1st. They are unusual in that along with each rule there is commentary that follows the rule that explains and expands upon what is expected in the application of each of the rules. The consultation that we did was extensive. We consulted in the drafting of these rules with the Criminal Lawyers Association, got feedback from them that was very helpful in the final format. We had consultation with the Crowns. We put the draft rules up on our public-facing website and invited the public to comment, and they did. The Advocate Society, the Bar Association, paralegals, lots of people have weighed in on this. And this distillation is the result of that consultation and that work. Plain language, simplify, and consistency. That's the goal. The 5 rules, I'm just going to go right to them. There is in the slide just sort of a high level what's contained in each rule. But given our time, I want to go directly to Rule 1. Again, Rule 1 is unique. Think of it as sort of a preamble. Rule 1 modifies and affects all the other rules. It imposes duties on all the people that are coming before the court, including the judge. It says that the fundamental objective of the rules is that proceedings be dealt with justly and efficiently, which is a good thing. It then goes on to define what justice and efficient means in the context of the rules. It says that in every proceeding, each counsel, paralegal, agent, and litigant shall, while fulfilling all applicable professional obligations, comply with the rules. It is the expectation of our court that these rules will be complied with. We have spent time over the last couple of months talking to all the judges, justices of the peace, and these rules will be dealt with differently than our rules in the past. You will not be automatically forgiven if you fail to comply with the rules. They are, in fact, a professional obligation on you to know and to comply with the rules. Let's get into the meat of it, Rick.
Thank you. I'm going to talk to you first about Rule 2, the application rule, and then Rule 3, the service rule. So how you'll go about if you're the one bringing the application, how you'll do that, then how you'll serve it. Norm, I know, is going to make some comments about them too. As I talk to you briefly about Rule 2, let me say to the group of you, and I know some of you from the room who I'm very pleased to see would have practiced in Ontario criminal law pre-92, before there was such an animal as rules of court introduced by the Superior Court. We pretty much copied them in 1998, and that was the set of rules for those of you who came on board then. The Superior Court has updated their rules in March. We've updated our rules in July, and we really believe that these rules mirror the practice in our court. They reflect the culture of our court and indeed your practice. And as I take you briefly through Rule 2 and 3, I want you to consider that as well. So in order to bring an application, you fill out one form. We have one form for everything, Form 1. You should have it in the back of your material. It's a 2-page document, and that will be the one and only document, if you're the applicant, that you'll have to fill out, whether it's to apply for charter relief, bring an adjournment of a trial, or apply to get off the record. So one form only.
That form is also, as I say, is on our website electronically, and you can fill it out electronically, and it will expand and give you as much space as you need in filling out the form.
You'll see that the contents as to what should be on it are set out in subparagraph 2, concise statement of the subject of the application, state the grounds to argue, detailed statement of the factual basis of the application. That's all we expect there to be. It may be that a transcript will be required, particularly for an 11B application, but again, no automatic requirement of it. May I note for you that if you're the party responding to an application, so if the Crown's the one applying for an adjournment, 2.2 will be your friend. You have to fill out one document, Form 2, which again you'll have a copy of, or download it from the court's website, 2-page document, and you're expected to include the same material that the applicant would, concise statement of your reasons for responding to the application. You'll see that we provide you with the ability to consent to it should you so wish. Response to the grounds, detailed statement of the factual basis for it. We've indicated in 2.3 that if the Form 1 application is in compliance with what we've indicated, no additional material is required, but you'll see that in the event that there is need for additional material, we've stated what it might be. I really encourage you to look at the commentary as well, because we've really tried to assist for the first time telling everyone what we have in mind. So you'll see that if you want to file additional material to help a factual or legal argument, that might include a brief statement of the legal argument. So in other words, there's no mandatory factum requirement for any rule, but if you feel it would be helpful, then you have the ability to do that. An affidavit, that may be helpful, for example, on an 11B application for prejudice, but again, it's not mandatory. Case law to be relied upon, other than well-known precedent, there's no requirement to fill a 40-page, to file rather a 40-page case if in fact you're going to refer to one paragraph. File the excerpt of the case that will be helpful. If it's Askoff or Moran, we have indicated in the commentary we don't want that type of material to be filed at all. An agreed statement of fact is something that you're encouraged to do as well. Let me take you through the other parts of Rule 2 and then, Norm, over to you. Let me draw to your attention that pretrial applications have a requirement to be heard at least 60 days before the trial, subject to a court ordering otherwise.
60 days? How could we ever get organized 60 days before the trial?
That's why there's one 2-page form to fill out.
Ah.
What are the pretrial applications? So you'll see that we've noted them for you: an adjournment application, getting off the record, disclosure, an 11B application for unreasonable delay. We appreciate that the 60 days is one of the new things that we've done. But here's the other side of it. There are over 600,000 cases in our court. The overwhelming majority of criminal trials are in the Ontario Court of Justice. If we don't have a proper, in advance time requirement to hear them, we're not going to be able to do anything on the day of trial if it's argued too near to the trial. And if it's argued, God forbid, on the day of trial, we really have a problem if a stay is imposed at that time, assuming the argument can even finish on that day. So we're mindful of the fact that there is a 60-day requirement, but we truly believe that it reflects the way that our court has to run efficiently and to be mindful of the considerations of everyone. And on the other hand, we're really only asking for minimal things to be done in terms of notice and what you have to do. So I've drawn that to your attention. Let me just go to one other aspect of what I want to tell you about. There is an ability, when you look at 2.7, to consent to an application. You have the form, that's the third and final form, where we only have 3 forms. Form 3 is the consent form. It is open to the parties to consent, subject to a couple of exceptions. We don't allow non-lawyers, non-paralegals to consent to a matter without the intervention of our court. And may I also draw to your attention that there will be some matters where, if the parties themselves wish to consent to a shortened time period, depending on what the subject matter of that will be, for example, an adjournment application or getting off the record, the court itself does have to be involved in the consent process. So by way of summary for Rule 2, everything that you need to know about an application is in that rule in terms of what you fill out. The forms are part of the rule itself. There are only 3 forms in the entire set of rules, and they're all referenced under Rule 2. Norm?
All right, thank you. I'd like to just back up a little bit. So there are some things about these rules that I like. I like that I can count them, because I'm counting to 5. I do like that. So there's a limited number of rules, and I don't have a big book like the Superior Court rules, and so at least there's few of them, so they're readable. I like the fact that they are clear, but as I discussed with the panelists in advance, there's a lot of great constitutions around this world, and they read great, but it's not the document that's going to govern. It's how these rules are interpreted and applied. And so a principle that says that the objective is just and efficient, that sounds good, but it's going to be where the balance is on efficiency and just and how these things are applied. So It's going to take some time as we develop, and it seems if what we're hearing, which I think we should take is going to happen, that there isn't automatic forgiveness and these rules are going to be applied. It's going to take a little bit of time to see actually how they work out. So I think a limited number of rules is helpful. It makes it so you can understand them, and so I think that that's good, and I think it's important that the objective, including that it's just and recognizing the rights of the accused, are right there in the objectives. So we should be, in my view, with a proper interpretation, should be fine on most cases. But when we look at it again, for example, when we're looking at these applications that need to be filed, I think there's really two issues where one is with respect to the timing, and I heard, how can we do it in 60 days? Well, there are reasons why we're going to have to sometimes abridge time and so on, and hopefully there will still be some flexibility on that. But it's going to be more in the interpretation. So if you take a look at Rule 2.1, I also like the fact there's only 3 forms. I think that's good. I like the fact that the forms are on the website and they're in Word, so you don't have to, you can just fill them in and work from them. So there's a standardized form, so that's great. But the devil's always in the details, and it says the application in Form 1 shall include a concise statement of the subject of the application, but 2C, a detailed statement of the factual basis for the application. And sometimes what is a detailed statement is something that I think we're going to need flexibility with, particularly in provincial court proceedings or Ontario Court of Justice proceedings, where sometimes we don't know what the evidence is. It's going to be evidence that's going to develop at trial with respect to charter applications. The officer hasn't testified. We haven't had a chance to cross-examine. We don't have the same pretrial mechanism. So hopefully there's going to be, looking at the overall objectives in one, we'll take a look into what a detailed statement is, and so that we're not being tossed out of court because we haven't given enough detail at the outset. The timing of the 11B, I suspect, will be an issue. There's different local practices, but to actually have it heard 60 days before the trial with a 30-day notice period to have served that, backs it up 3 months to order the transcripts, and you're really effectively making the decision, it seems to me, almost when you're setting the date, that you're going to have to be saying, I'd like to set 2 dates. That's the date you've offered for me for trial. Well, you need to offer me also a date for the 11B. And so is that something that we would do in the set date court, or do we go up to how do we get that date?
I think you're right. Practice will vary. If you're in Napanee, the trial's over. But for many places, you can get it through the trial coordinator. You can, who will know who the trial judge will be, or will have that in mind when they're scheduling the case. If it's something that's complex, you might want to have a judicial pretrial or a pretrial with the Crown, counsel pretrial. And I think either one of those would be a good place. And I agree with you. This is a significant change. But when you come to set that date, and it's the second or third trial date that you're setting, and it's a long way out, you know when you're setting the date that you intend to bring this motion. So, but human nature being what it is, we don't really get organized on it until the last minute. And then we come in and argue it on the trial day, and we waste the witness's time, and frankly, you waste the court's time. If you're successful, why have we set aside 4 days of trial that's resolved in a day? So we really want to try to use your time better and to protect the interests of the witnesses.
Okay, well, some of these 11Bs applications, though, may take about the same length as the trial. You know, on an impaired driving, is there going to be time limits on the 11B applications too? Will these rules have time limits on how long we're going to be able to argue motions?
I suspect that increasingly our court is going to be interested in limiting your oral argument, just as they do in the Superior Court and the Court of Appeal. You can't come in and give an oral argument for a day and expect to use the court time. You're going to have to focus your argument. If it's written, that's fine, but focus your argument so that it can be dealt with and the issues addressed more efficiently than we have in the past.
Okay.
Service?
Well,
Service, oh yeah, I had a question about service too. With the rules, it seemed to indicate that we could serve forms now electronically, but then the next rule underneath also said that if electronic filing technology is available and a practice direction authorizes it, documents may be served electronically, filed electronically, or both. Are we able to serve electronically regardless of whether we can file electronically? So the answer is that yes?
That's the idea. Council should be able to exchange their documents electronically. But we still don't have the capacity to receive documents electronically for filing. And there might be the odd judge who isn't quite sure which button to press. So we say for now, give us file the hard copy. I think there are changes coming to ICON that will, in the future, permit electronic filing, but we're not there yet.
But electronic service is fine?
Yes.
Let's go, in fact, then to Rule 3 very briefly with service, and then get into case management, which was one of the things that you just flagged about time limits. So very briefly for the Rule 3 service, which is much shorter than Rule 2, you'll see that to serve the application, the applicant has to do so at least 30 days before the hearing of the application. So effectively a 90-day window. Should be heard 60 days before the trial, and the proof of service 30 days before the hearing of the application. The response is given a 15-day window. These time periods may be shortened. They could be lengthened by a local practice direction, order of the court. Note in paragraph C, so it's Rule 3.13C, the parties themselves can consent to shortening or lengthening a time period, but note the one exception that I mentioned before. An adjournment application or being removed from the record requires the judicial officer to be involved in the consent. We just touched on methods of service, and in the future electronic filing technology coming before the court.
Rule 4 deals with case management. We've never had a rule dealing with case management. What happens at a pretrial? What material is expected for a pretrial? What material is expected for a focused hearing? I love Rule 4.1. It's my power rule. I go home and I read this to my wife. We have the power to make any direction or order in relation to the conduct of the proceeding that would assist in ensuring that it is conducted in accordance with the fundamental objective. That's the court having authority over its own proceedings and being able to make the appropriate orders to make sure that the matter is heard fairly and justly. Judicial pretrials are done differently all over the province, and there are different expectations of the judiciary around the province. We wanted to bring some consistency to that, and you will see that there is now documentation that is required. The court is to have the synopsis 3 days before the pretrial. We've only got 20 minutes to do a pretrial. We don't want to spend the first 10 having counsel tell us what the facts are. It's really a waste of your time. Give us the synopsis, we'll read it in advance, and we'll all go in ready to go. It's very important as well, and this is now a rule of the court, that parties attending the pretrial must have decision-making authority and be able to bind their client on decisions that are made. This can be really tricky. I mean, if you have a conditional retainer and it's conditional up to the pretrial, see if you can resolve it. How do you bind then the trial proceeding, whether you're doing it, another counsel's doing it, or the individual is self-represented? And I think that raises some professional questions for you about getting written instructions at the point that you go into the pretrial. The expectation is, though, that if there are admissions that are made at the pretrial, that they would be recorded and that they would be binding unless there is a change in circumstances. And that shouldn't be too shocking. The Crown or the defense have a right to rely on those admissions when they go into trial. The pretrial judge will have powers then to confirm or amend time estimates for trial. Time estimates are a big part of a pretrial. Set timelines for the exchange of materials on the application. If it's different from what's required in the rules, then this is where you work out those differences. Set the times for applications, the dates for applications. And often, if you can't get it all done in that pretrial and you need to come back, you need to give further instructions, well, then we can set another pretrial date.
Before we leave pretrials, what are the consequences, or what's going to happen if the lawyer isn't in compliance with being in a position to have decision-making authority? And because of the tables where I sit normally, I'm not worried about myself, I can be there. But I go to lots of pretrials where the Crown's not going to be the trial Crown. It rarely is the trial Crown. And they say, well, it's not my file. Like, is there going to be any consequence to the Crown to actually deliver up people to the pretrials that can make decisions?
If this goes over, in my view, if this goes over because one of the counsel is not does not have the authority to make decisions, then any time it goes over will count against them on 11B. So there are consequences for not being there. We're talking to the Crowns. We're telling them they have to do this. You know, one of the areas of flexibility in the rules is there's provision there for attending by telephone. Now, I know that there were places that let you do that, but it was always sort of as a special favor. Well, now the rules provide that, you know, with the court's permission, you can attend a pretrial by telephone. Because we're going to know in advance when the pretrial is, if the lawyer doing the pretrial needs instructions from the Crown counsel who has carriage, they need to get those instructions in advance, just as defense counsel need to get their instructions in advance. So we're all ready to go when we go into the pretrial. And if there's an issue, well, then they can, in an emergency, call it in.
Okay, and the ability to do it by telephone or Skype or whatever is something that is important to me. Obviously, I'd rather be there in person if I can, but especially if you practice in more than one jurisdiction and you have to drive for an hour or an hour and a half to do a 20-minute pretrial and back, it's tremendous waste of counsel's time and expense to their client. The rules allow for it, but it says if the judge permits it, I guess, which would be a local type of decision, would there be encouragement from your office to the local judges that to accept it by telephone when there's considerations such as travel?
There are occasions, this will shock you, don't let it outside of this room, but there are occasions when the judge wants to have the people in the room because they feel that they have a better chance at getting issues resolved with people there. But there are also lots of times when it can work very well by telephone. I don't think it's a local decision. I think it will be an individual decision. I certainly encourage when I talk to the judges to use technology. We're going to be increasing remote technology in our courts. Why aren't we using them in our administrative processes? So yes,
Just on that point, I've conducted a number of pretrials at the old City Hall by telephone, and usually I'll ask the parties who will appear. I find it's more common where there'll be co-accused and there'll be two defense counsel who are able to attend in person, but the third can't, and rather than find a later date for the pretrial, we then do it over the telephone. And very often I find that I ask the parties in advance whether they're all right with the telephone pretrial, and sometimes it'll be the defense counsel wanting the Crown to attend in person, or the Crown wanting one of the defense. So I find that there's a lot of flexibility, but I can certainly see in the future that pretrials via Skype, via telephone, I mean, we're doing that under the Provincial Offences Act. We need to catch up, and I think where appropriate, they can be very effective.
And you raise an excellent point, Norm. I mean, you need to be paid for your services. And if you are representing somebody in Belleville, to drive to Belleville for a 20-minute pretrial and back, you're not getting paid for your services. And frankly, me as a judge, I'm thinking, well, then the likelihood is that they may not want to have a pretrial, and I lose that opportunity to talk to you and to learn about what the issues are. So I expect that we will see more and more of this.
And for the pretrials, certainly hasn't been my practice in the past, and I don't know if I do it, but the rules talk also about the defense filing written material with the judge for the pretrial. Is that something that you're expecting to receive, or?
No, we just want to be even-handed. Sometimes there's medical reports, there are reports that they want to bring in at the pretrial. Usually when you're talking, you think you're going to be talking about sentence at that point. And just any material you want to rely on, make sure we get it in advance so we're ready for the pretrial. Okay?
And if we submitted material at that, would that be privileged material? Would that be protected? Or?
You know, in truth, I haven't put my mind to that, but I think if you put on the material without prejudice, that you've then answered your question. Focus hearings. Criminal Code says explicitly refers to, and as does Code Lesage, the opportunity to make rules around focus hearings. Focus hearings are really pretty rare. We don't do that many preliminary hearings anymore, but when we have them, they can be for big cases that involve multiple accused and that we expect will take weeks and weeks of time. So it's important that we use the time wisely. Rule 4.3 on focus hearings really just sets out what's in the criminal code. These are the things that you need to do for a focus hearing. About 15 years ago in Ottawa, a practice was started of having examinations for discovery in the absence of a judge during a preliminary hearing where committal for trial was not an issue. And that's grown over time and has gone into other jurisdictions. And we thought it was time to make explicit reference to that in the rules, and as a part of that reference, say, it's an acceptable practice for our court, but it isn't every witness that is appropriate to be heard on examinations for discovery. And explicitly, witnesses under 18 or where there is a complainant of sexual or physical violence, it's not appropriate to examine that witness in the absence of the judge. Rule 5.
The final rule that we have really addresses a couple of different points, and let me go over them briefly with you. The first one is practice directions. There tend not to have been many of them, but The issue here is that if there is a practice direction issued by the chief judge of our court or the associate chief judge of the court, they have to be publicly available. So you'll see that they have to be posted on the website of our court. They may apply to a region, they may apply to the province. You'll see 5.2 addresses the forms, which we've touched on before. We've gotten rid of the 15 forms in the last set of rules. There are only 3. There won't be any new forms without, again, posting them onto the website of the court and making them available over the internet. Let me, though, conclude with 5.3, which will be something that we hear a lot of comment about. The rules read well, but what about when I'm not in compliance? What happens? We'll often hear from judicial officers. Are there going to be teeth to the rules? How do they get enforced? And we've tried to make it clear, both through the rule itself, 5.3, and the commentary. And it's not accidental that the commentary is actually longer than the rule. The rule itself gives the court a discretion to excuse noncompliance with any rule at any time, to the extent necessary to ensure the fundamental objectives set out in Rule 1.1 is met. So if you were seeking non-compliance with a time period, we would expect you to have regard to the purpose of the rules and go through the relevant considerations, something not within your means, illness of a party, not being able to proceed on a date or give more timely notice. I think you'll find that a court will respond to that very differently than, for example, the Crown knowing that an officer has been unavailable due to an annual program or vacation date and not giving a timely notice. So very important to be mindful when you're seeking non-compliance permission from the court to address the fundamental considerations. The commentary, I think, will be very helpful for everyone, and let me take you to it very briefly before turning it over to Norm. We expect that the parties, meaning all parties who appear before the court, will be familiar with the rules and will comply with them. We state afterward it is a professional obligation to do so. We try to make it clear that these are our rules, but they're really the rules of everyone who practices in our court, and everyone needs to be familiar with them. However, on rare occasions, there may be circumstances that prevent compliance. So we recognize that there will be occasions where someone cannot comply with them, but the word rare is used for a reason. Note that we go on to indicate the court has a discretion to excuse noncompliance with the rules to the extent required to ensure a fair hearing. However, consequences may result from noncompliance, which will include, in appropriate circumstances, simply a dismissal of an application without a hearing on the merits. So in terms of 5.3, the power to excuse noncompliance, a judge always has the ability to allow a party to continue without complying with the rules. The reasons for noncompliance are important. We've tried to indicate that everyone must be familiar with the rules and act under them. Judges retain a discretion to excuse compliance, although we anticipate that it will be the rare case where that should happen, everything else being equal, and there are consequences of non-complying. My final comment, Norm, before turning it over to you, is that, again, I would encourage you all to look at the rules as a whole. Yes, we expect compliance with them, but we've really tried to make them easier to comply with. There are fewer of them. They're in plain language, they're minimalistic, and accordingly, it should be easier to comply with these rules than any other rules that we have had or you will have. You don't have to worry about page margins, font size, color of application records, but we want the forms to be filled out properly and served in the appropriate time.
Just following up, I did receive a question. With respect to the forms that are on the website, we can fill them, are they set up with the technologies that allows for word processing abilities such as spell check and so on the forms? Do we know?
I don't know. I've never made a mistake in spelling on the form.
And then I had another question with respect to, I think it's helpful that the only rules that will be in effect are the ones on the website, so when I travel to different locations, I'm not met with rules that I've never heard of. Does Rule 5 then end the practice of showing up in jurisdictions where a judge says, in my jurisdiction, you have to have a factum if you're looking to exclude evidence on a charter application? Am I going to be safe from that now? Or will they be able to send their own local practice directions down and get them put up on the website?
You'll be safer. I think part of what we're looking for flexibility in these rules. Flexibility for you, flexibility for us. And I would expect that. There will be processes. I know that there's discussions ongoing now in Toronto to have a practice direction for Toronto that mirrors these rules in terms of service requirements and the hearing of motions that will be universal across the 7 courtrooms in Toronto. Hey, it's been a long time coming. Will there be judges who locally require things that are not posted as a practice direction? There may be. There may be. There are local practices that don't reach the level of a practice direction. Practice direction is a term of art. It is a direction that is arrived at collaboratively in the community, whether that's the province, the region, or the local office, that is signed and approved by the regional senior justice, is then posted on the website. And we will have a place on the new website where all the practice directions for Ontario will be posted alphabetically. So if you're going to Belleville, you'll know, you can look and see whether Belleville has a local practice direction. That's not up yet because there aren't any practice directions yet. But I know that Ottawa is another one. There are a couple of communities that are working on one. When they're done and in both official languages and signed off and posted, you'll know about it.
And Norm, may I say in relation to that one thing that anyone in that position can always say is that these rules make a point of stating there is no factum requirement. There is no mandatory affidavit requirement. That said, you may find it helpful. Never mind the judge or the Crown in cases where you're the applicant. You may find it helpful to file a factum or to put forth an affidavit. So I think as the new rules regime will begin, we'll hopefully see a lot of flexibility in the interpretation. And there may well be cases where the defense or the Crown will want to file additional material that, strictly speaking, is not required.
Yeah, let me just say one word quickly about affidavits. Frankly, part of the impetus of this is I don't want to see another affidavit from one of your secretaries. They're nice people, but I don't want to read their affidavits anymore. You know, too often, and requiring affidavits for every application was a barrier often to self-represented accused who had legitimate things that they wanted to bring before the courts. But we're not saying that affidavits are never required, because there are many situations in law or in the criminal code where you are required to file affidavit material. On charter applications, they're heard on evidence. Affidavits often provide the evidentiary basis. You will need to file an affidavit in that situation, or call viva voce evidence. So it's not that you never have to file an affidavit, it's more that you don't always have to file an affidavit. And get excited about the consent form. We've never had that before. You won't have to come to court. You can get your motions done in advance. It'll be a basket case. The judge will sign them in chambers. If they have a problem, they can send it down to the trial coordinator to look at. But the consent is I think, an important part of the new rules.
Okay.
She says wrap up.
She says wrap up? Okay. I guess then we'll wrap up. I just wanted to say one last thing with respect to the mercy rule, which is 5.3. If there is a concern, it's in the commentary where the sentence reads, however, in rare occasions, there may be circumstances that prevent compliance. And if I'd been drafting a rule, I certainly would have liked a rule would just say, however, on occasions. And the inclusion of that word rare, I hope isn't going to receive, it'll be interpreted back fairly and justly with what's at stake, because it doesn't seem to advance anything if motions are going to be dismissed out of hand because somebody hasn't met a procedural requirement. Surely the rules are to ensure that justice is done and they can't become, the process can't be what it's
Well,
about.
and that's what Rule 1 says. It's got to be just. And you'll be happy to know that as a result of the input of the Criminal Lawyers Association, I took out the word very in front of rare.
That's very nice. Thank you for coming.
Ladies and gentlemen, just to wrap things up, after today and attending here today, you should know how to ethically exploit all loopholes for your client charged with over 80 with a brick of coke in the trunk while fleeing a sex assault. So long as the rules don't get in the way. Thank you very much. Thank you for the Seneca staff for their support. Thank you for G at the back doing tech support and the Chestnut staff. Thank you to the speakers. Thank you to our president for being here today. And thank you to all of you for attending. Thanks so much, guys.